we're going to get started now. Why don't we introduce ourselves first? My name is Erik Daly. I am partner in the corporate and mergers and acquisitions group here at Miller Johnson. Marie, do you want to introduce yourself and the rest of today's panelists?
Yes, thank you, Erik. Good morning, everyone. Thank you for taking some time out of your busy days in this exciting and challenging atmosphere to connect with our team this morning. Just in terms of brief background, we thought it would be productive to host daily webinars where we bring folks up to speed, answer questions. Today's group of panelists focus generally in business services and litigation. Erik, you've heard from. He'll be leading the discussion, moderating the topics as we move through them. My name is Marie Carson. I'm also a member in the corporate group. I do transactional and general corporate work, and I'll be chiming in on topics that are of particular relevance to clients I work with. And to round out our dynamic trio this morning, we have Jeff Muth, who's a partner in our litigation group. And there's some really interesting overlap between what we would think of as kind of business topics and matters that affect folks in dispute situations. And Jeff has experience navigating or threading that needle. And he's also probably the best equipped to speak to insurance. Before I pass the microphone back to Erik, I just want to highlight for everyone that given the circumstances, all three panelists find ourselves working remotely. So we're going to do our best to have some pretty seamless transitions, but just a reminder that we're lawyers and not broadcast professionals. So we appreciate your patience if there's any hiccups or clunkiness in our delivery. If you tune in every morning at 8 a.m., I expect you'll see us turn into professional broadcasters in no time. So with that, back over to you, Erik.
Thank you, Marie. And thank you again to everybody who's joining us this morning. Following a webinar last Friday that we held on the rapidly evolving laws and related considerations in the employment arena, and after tracking the unimaginable ripple effects of COVID-19 on our civic, commercial, and social life over the last week, really longer, Miller Johnson formed a cross-functional team to deliver timely and pragmatic resources to our clients and other community members. We believe that we can best mitigate the fallout from this crisis by working together with clients, government, community organizations, and other professionals. We practice and live in a community that prizes collaboration, intellect, loyalty, candor, and ingenuity. These will be our guiding daily principles as we navigate through these uncharted waters. Before we proceed to the substance of today's program, let's first pause to consider the many thousands of people across the globe already impacted by the pandemic, as well as the many thousands of lives, families, and jobs that will be impaired in the weeks and months ahead. Here in West Michigan, healthcare professionals, pharmacists, grocers, and so many others are bracing for this storm. While we cannot stop what may come, we can adopt a constructive mindset that recognizes our shared sensibilities toward our coworkers, employees, business partners, local economies, and the principles of law. With that said, as Marie mentioned earlier, our topic today is business contracts, specifically looking ahead to those issues we are most likely to encounter in these turbulent times. With many businesses all but closed for the foreseeable future and the resulting disruptions to production, supply chains, and flow of commerce generally, the term we're most likely to hear in the context of contractual performance is force majeure. While different countries have somewhat different approaches to force majeure principles, we will focus on the generally prevailing concepts under United States law, recognizing that each state within the United States will have its own variations on that. And with that, I'm going to turn the microphone over to my partner, Jeff Muth, who will provide an overview of some of the most important considerations in this arena. Jeff?
Yeah, thank you, Erik, and thank you for your introductory comments. You know, as Erik mentioned, these are truly unprecedented times, and it's hard not to feel overwhelmed by everything that's happening on a daily basis as this COVID-19 pandemic continues to grow. My hope in talking about both force majeure clauses, and then I'll also touch briefly on business interruption insurance, is to make the process of evaluating your various contractual remedies or risk mitigation opportunities less overwhelming, or at least not an additional cause of that sense. So in talking about force majeure clauses, and I'll be honest that, you know, in the 20 years of my practice, from a contract negotiation standpoint, these clauses get very little attention. And it's not surprising in that they are designed to excuse performance, you know, under a contract when an unforeseen extraordinary event prevents a party from fulfilling its contractual obligations. So usually not a key deal term when you are negotiating a supply contract or a construction contract. And most of what you'll see in in your contracts, I would presume, are fairly boilerplate force majeure provisions to the extent that they exist at all. If your contracts or your key contracts are those that do include force majeure provisions, there are a few things that are very important to remember as you look and try to determine if that force majeure contract is capable of excusing performance in that particular setting. First, those provisions are construed or interpreted very narrowly by the courts. So in order to trigger a force majeure clause, the first thing that the clause needs to include is a specific reference to the type of event that you or the non-performing party is using to exclude performance. So in this COVID-19 situation, that clause would need to include specific reference to a pandemic or a viral outbreak if that was the event that you were relying upon to excuse your performance. Additionally, you'll see in force majeure clauses things like governmental action, civil authority. Again, with, for example, yesterday, San Francisco putting its entire population on lockdown. If that event prevented your company from performing under the contract, that could be looked to under the express language of that provision to excuse performance. But it doesn't stop there. As you go through this analysis, the second prong of that analysis is that the event, as stated in the clause, was unforeseeable, and the party relying upon it has to show that it was either unable to mitigate the risk of the event, or that it took steps to mitigate the risk of the event and was unable to do so. And then third and finally, the event has to render the performance impossible, not simply commercially undesirable or commercially impractical. It has to render the performance impossible. So it's a fairly high bar, and it really turns on the express contract language as well as the specific facts of the situation. With that, I don't know if there are any questions Erik, that you have that jump to mind in talking through that analysis, but I'm happy to answer any.
Yeah, Jeff, thank you very much. This is Erik Daly speaking again. I think what we will see as we go through these topics are some prevailing themes, which I would put under the rubric of evaluation, mitigation, and communication. For businesses and clients that have sort of standard form agreements that they have empowered people to use that may not always see a legal review because the terms, may have been approved a year ago or 2 years ago. Something that was unforeseeable at that time to many, this particular epidemic is now clearly foreseeable and is something we're dealing with. What would you suggest in terms of under that rubric of evaluation, mitigation, communication? How do we deal with that in terms of getting out in front of mitigating future risk?
Well, courts are always going to look critically at what the non-performing party has done to proactively mitigate risk. And I think you're going to see, as litigation, undoubtedly is going to increase in this area, courts spending a lot of time focusing on the active mitigation efforts of the non-performing party as soon as they became aware of this potential existential threat presented by COVID-19. And what you're seeing on the global supply chain from a mitigation standpoint is when the COVID-19 virus initially impacted China and started impacting global supply chain as a result, what, if anything, did the parties relying on a force majeure clause do in attempt to shift supply chain, find alternate suppliers, negotiate with customers to extend delivery? Those are the types of things that courts are going to look at in that example with respect to mitigation efforts.
Thank you, Jeff. I would offer one other suggestion, which seems just pragmatic to me, is I know we're all pressed for time dealing with the world of activity from day to day, but given that this is a foreseeable risk clearly at this point, we need to revisit standard contract terms and conditions to make sure that our force majeure provisions contemplate this risk directly and to the best extent possible deal directly with what the consequences will be for future contracts, setting aside contracts that are already in place. So let's stop. Sorry, go ahead, Jeff.
Well, and that's a really good point, Erik, and it brings me to something else that, that may seem self-evident, but I would highly recommend for those clients who are attempting to mitigate, make sure that you are documenting your mitigation efforts and attempts in real time to the best that you can. Because if you end up in a dispute later, you're going to have to cite to those attempts and the outcome of those attempts in any type of dispute, whether it's arbitrated or litigated.
Thank you, Jeff. Why don't we move on to business interruption insurance briefly? This is not really a direct contractual term, although some contracts may require parties to carry certain types of insurance. And I don't know that we've seen how this will play out yet, but I suppose it's possible or likely that, current circumstances may make it, more challenging to economically obtain required business interruption insurance. Jeff, could you speak briefly to kind of what you're thinking about and seeing in this area?
Yeah, sure. Thanks, Eric. So business interruption insurance, is typically found in in your commercial general liability policy or your property insurance. And what business interruption insurance covers is a little bit self-evident in the title, but it covers things like lost revenue, fixed costs such as rent and utility expenses, expenses from operating from a temporary location, resulting from disruption in a business's operations. Typically speaking, every policy that provides business interruption coverage requires some physical loss or damage to the business operation. In some policies, physical loss can be broad and include loss of use of premises, but typically the insured has to incur some type of loss that's directly related to its business operation that impacts its ability to perform. And, I did a very brief post late last week, and the example I used for a typical business, interruption coverage analysis is if you had a hotel that had employees or customers infected by the virus, requiring it to shut down or otherwise self-quarantine for a period of time, it would likely trigger that loss of use or damage to property triggering event under the policy. If you were a food supplier to that hotel and simply lost that contract for the period of time that the hotel was shut down, it likely would be excluded from coverage because you as the supplier have not experienced a physical loss to your property. So that's a starting point for how coverage is typically triggered. Since the SARS outbreak in 2002, 2003, most standard policies include a virus or disease exclusion to coverage. However, each policy is different. Insureds have the ability to negotiate or broaden the scope of that coverage. And so while I would say that if you just have a standard off-the-shelf commercial policy, that virus exclusion is probably going to prevent you from seeking or recovering collectible insurance. I still think it's a worthy exercise to go through the details of your policy to determine, one, is the exclusion there? And two, if so, is there another triggering event? Oftentimes, business interruption insurance will also include civil authority basis for triggering coverage, like the city of San Francisco putting its population on lockdown. Civil authority actions that really render the operation of the business impossible and prevent access to the business operation. So those are the overarching considerations in looking at your business interruption insurance. And then finally, through addendum or riders, some companies will negotiate supply chain coverage, which covers disruptions in supply chain arising out of similar events with their suppliers, or contingent business interruption insurance that's very similar to supply chain insurance.
Thank you, Jeff. That's a very, very helpful overview. One quick question on the potential civil authority or civil action trigger for coverage. We're seeing some of that obviously now at a state and local level here in Michigan. Any suggestions just in terms of people documenting or otherwise kind of memorializing at this early stage, what they are doing in response to that? Obviously, if they have to shut down their business, they're doing that. But what other things, are they taking actions with regard to employees? How do they start laying the basis for an insurance claim later by taking some steps now to document what they're doing?
Well, I think the first step is really going through and analyzing the language of, the policy itself, because all of these coverage determinations turn on the express provisions of the policy. If after doing that, you think there is a reasonable basis for coverage under your business interruption clauses, the first thing I would do is tender the claim to your carrier to preserve the claim. The carrier will, take notice, provide a claim number, and then you're going to have a bit of a back and forth. They're going to want details around the claim, and obviously the more that you can do to establish that the claim is directly related to both a triggering event and not excluded under the various exclusions to coverage under the policy, the better off your chances are that you may receive collectible insurance at the end of the road. I will say this, carriers are going to be inundated with claims. And so I would anticipate that these claims are going to be fought with a sense of vigor from carriers, because if they paid every single one, they'd all go out of business. So my anticipation is that these claims are going to be difficult and costly to pursue, and the more that you can do up front to really remove any wiggle room from the coverage analysis, the better your chances are to maybe come to some kind of negotiated result with your carrier as to the impact and the damage.
Okay. Thank you, Jeff. That's very helpful. And I think that leads well into our next agenda item, which relates to performance standards under contracts, and ties into this idea of understanding your flexibility for performance and potential avenues for mitigation. I'm going to turn it over to Anne-Marie to briefly talk about some of the different standards that you might encounter under your commercial contracts and where they offer more or less flexibility. Anne-Marie?
Thanks, Erik. Hello again, everyone. Before we dive into the wonderful world that is the variety of performance standards, I just wanted to make folks aware that if you've logged in on your computer, there's a Q&A button at the bottom of the screen. You're welcome to submit your questions. If time permits at the end, we'll try to answer a few of those. Otherwise, we'll use them as feeders for tomorrow's webinar. And in addition, you'll be able to, when you register for tomorrow's event, submit questions then as well. So turning back to the topic at hand, performance standards can be one of the most interesting things that get negotiated in commercial contracts. And why I say that is because one word can represent thousands of things. So if we look at the three most common, or what I would say are very frequently seen, they would be grouped as commercially reasonable efforts, best efforts, and ordinary course of business. So just to go through these and break them down, if we look at what does it mean to operate in the ordinary course of business, I think all of us would agree that nothing is operating in the ordinary course of business right now. So that when you think about your contracts, if you're getting them out and you're dusting them off, understanding what is meant by the performance standards and how those standards intersect with the reality we all find ourselves in is a really helpful task. So going from ordinary course of business to the next extreme, which would be then best efforts. And what that means is giving more than what you would in an ordinary commercial situation. You're prioritizing your level of performance to the best of your ability. And then falling somewhere in kind of one of the shades of gray would be a standard that we refer to as commercially reasonable efforts. So that would be thinking of similarly situated businesses in the industry. What would be the commercially reasonable effort that individuals would allocate to performance under the contract? So this topic isn't necessarily one that's going to provide great answers right now, but it is one for people to start thinking through of, have I made any commitments to some of my customers that require the highest level of performance standards? Do I have certain supplier or customer relationships that I need to prioritize based on the level of performance I've agreed to with them? Jeff, I don't know if you have thoughts about how this might intersect into how these disputes get resolved down the road, but I would be curious to hear from a litigation perspective if you think performance standards are going to be something folks look at pretty closely when we come to the world of resolving disputes.
Yeah, I'm almost certain that they will. And you really have two concepts that dovetail with one another. One is kind of commercial reasonableness, and then mitigation. And so, courts are going to look very closely at whether or not the actions taken in accordance with your performance standards are both commercially reasonable and had the effect of mitigating any damage resulting from being able to fully perform under the contract.
Thanks for that insight, Jeff. I think, we were going to move to rationing provisions, but since we've hit directly on mitigating damages, it makes sense to just continue that discussion. It's something you've heard brought up frequently through this discussion, and it's one that we'll continue to talk about, but documenting and taking note of what actions are folks proactively taking in light of the unusual circumstances is most likely one of the best ways we can all be utilizing our efforts to mitigate damages down the road and to set ourselves up for success. With that, I'll turn it back to Erik to touch on the new topic of rationing provisions and what that means in this climate.
Yeah, thank you, Anne Marie. And before moving on, I would stating the obvious, the concept of mitigating damages and evaluating performance standards, we're in a different world now than we normally would have been 4 months ago, where in evaluating what is commercially reasonable or what is in the ordinary course of business, our clients and other businesses are going to need to weigh truly commercial considerations against human considerations, maybe in some cases literally life and death situations, and those those decisions aren't ones you need to take alone. I think consulting with your internal counsel, with your senior management, as much as you can, so that people may not be making those decisions on an island, is going to be paramount. So Moving on to rationing and allocation provisions, I think, again, in keeping with the overall theme of evaluation, mitigation, and communication, businesses need to understand what rights, either as a purchaser of goods or services, and what obligations as a supplier of goods and services they have or they are subject to in the face of capacity or production shortages. Some agreements that are already in place will be very clear about the parties' rights and obligations when it comes to allocating limited resources. In other cases, there may just be a reference to the supplier making a fair or reasonable determination about how they direct their resources or their output. I would venture to say most contracts will be silent on this topic, and are going to leave businesses and their customers in a situation where they need to communicate with one another very clearly, if they aren't already, about how those decisions to allocate limited resources are being made, and to provide more visibility so that customers purchasing from one capacity constrained supplier may be able to communicate further with their customers about constraints that they see coming in the supply chain. So I think it would be perilous to leave this to chance if your contracts are silent about how you're allocating resources, and it'd be best to over communicate with both your internal constituents, but also with your customers and vendors about how you manage through those issues as they begin to arise. And I think one area where that intersects with public policy will be potentially what happens when, government agencies, federal, state, local government need to procure goods that we may not currently think are sort of something that the government would need to purchase. To what extent are our businesses going to need to prioritize or want to prioritize supplying goods and services to first responders, to government agencies, and redirect their production capacity to those purposes? And what does that mean for the purely commercial relationships? I think any business, there are some businesses where that is an obvious potential reality. If you're in the medical device space and you have any capacity to produce ventilators or parts that could be used in ventilators. But I think if you look further down the supply chain, if you're supplying one of those types of businesses, or you produce something that could be used in the healthcare context, I think, it would be prudent to proactively consider to what extent, your resources may be requested or required to be redeployed. And again, to communicate clearly with your existing customers, your internal customers, if you supply some of these, if you supply anything to internal business units, and how you're going to have to redirect resources. It may not spare you a breach of contract claim at the end of the day, but coming back to the point of mitigation and communication, it may help alleviate some of the damages or the toll that it takes on your business in the long run, if you can think clearly and communicate clearly about those possibilities now. We're going to keep moving. Another topic that kind of relates to the eventualities and the prospects for defaults under commercial contracts is cross default provisions, and understanding and evaluating what happens to your suite of arrangements across the enterprise, should you have a breach of contract under one agreement, a material arrangement with a key customer or a financing agreement, I think it's critical that organizations understand where they may have agreed to cross default provisions in the past, so that if they, perhaps through no fault of their own, breach one agreement, it may give rise to termination rights or automatic terminations under other agreements. And I think circling back to some of the other things we've talked about, the more that you can communicate with counterparties about the possibility of a breach or performance that doesn't quite meet the standard required under the agreement, and negotiating amendments or seeking accommodations to your contracts to avoid a formal breach or default, the more proactive you can be in identifying and mitigating the potential kind of cascading effects that could flow from a breach or a default under one of your agreements. So I think here again, the importance of communication with your counsel, your internal team, and your external customers is going to be really important to make sure that you can cut off a potential domino effect with agreements. We've touched on amendments and seeking accommodations already. I just think here again, to reemphasize, to the extent that you see issues coming, I think, engaging in discussions earlier than you normally would with business partners, and talking to counsel or others about how to best position those discussions is going to be very important and may help, mitigation efforts, avoiding cross defaults and other similar negative effects that you could face if you don't proactively seek accommodations or amendments when you're in a perilous situation. Short of that, or I guess beyond that, would be, evaluating termination rights that you may have or that you may be subject to. I'm going to turn it back over to Anne-Marie to talk a little bit about, what steps you can take to better understand the possibility of termination of contracts, whether it's your termination or one that you may be subject to. Anne-Marie?
Yeah, thanks for that, Erik. So in this great situation we find ourselves in, where we're whirling with an incredible amount of uncertainty, one of the things everyone will benefit from in terms of commercial contracts is dusting off and reviewing the provisions of the agreement that specifically relate to which party is able to terminate or cancel, under what conditions are they able to do so, and what, if any, are the consequences or assistance required in the event of termination. Now, the discussion around termination has to be had within the greater context of mitigating damages, proactively seeking accommodations, communicating, and everything we've talked about to this point. But in terms of the actual termination provisions, it'll be helpful for folks, customers, suppliers, everyone, to identify what are their key contracts. Within that world of key contracts, who is able to terminate? Is it you? Is it the counterparty? Under what circumstances? And then in the event of termination, how long is one or either party on the hook for? And how does that interplay with any considerations around force majeure, rationing, mitigating damages, or the other topics we've discussed to this point? I think we're a little bit of a broken record on mitigation, but thinking through when there's a termination, whether it's because of impossibility of performance, or there's a payment default given the circumstances that triggers a right of termination, how are we proactively addressing the mitigation of what that termination might mean for our own internal constituents as well as customers, suppliers? I think this one, like most of these that we've discussed, does need to be thought through of how critical is this contract? What are the consequences in the event it's terminated? What, if anything, can be done now proactively to mitigate damages down the road? Jeff, I'm not sure if you would have input on how termination of contracts might be viewed in the litigation context down the road.
Well, in the litigation context down the road, if you've got contractual termination rights, irrespective of their scope or requirements, courts will enforce the express language of the contract, and they're required to do so. They cannot read terms in or out of those agreements in order to effectuate some different result. However, I think when you're evaluating, termination rights, I think you also have to, evaluate the broader business implication of terminating a key contract with either a supplier or a customer. And I think this goes back to the overarching, theme of this discussion. When we're talking about, COVID-19 or any event that really doesn't discriminate against customers, suppliers, end users, everyone in the supply chain is going through this same analysis because everybody is impacted in some varying degree. And so it really underscores to me the importance of actively, proactively communicating and working collaboratively with those members of your supply chain to come to an acceptable, albeit probably imperfect, resolution. It goes to mitigation, it goes to commercial reasonableness, all these things that the courts will look at if you get there. So I think as we walk through all of the things we've talked about, to me, those are the overarching principles to me. I think it's very important that you proactively communicate with members of your supply chain and really try to come to a amicable resolution to these issues that everyone is facing within the supply chain, because and maybe this is a time to segue into enforcing agreements. The litigation option to resolve these issues is going to be extremely timely, based on the fact that courts all over the country are shutting down except for essential services, which most courts have defined as felony criminal matters, domestic dispute issues, and child custody issues. Most courts have severely curtailed or completely eliminated hearing civil matters. That would include, matters for injunctive relief requiring specific performance under a contract. The types of things that you could normally get into court on an emergency basis in civil matters is going to be extremely difficult to get before a civil judge. And the delays on the civil side of the docket is going to feel the brunt of those delays, because courts view those cases as simply being fought over about money. Well, criminal cases are, impact somebody's, life or liberty. So the more contracting parties can do to proactively engage their suppliers, their customers, to come to an acceptable, albeit imperfect, resolution, I think you're going to be ultimately dollars ahead. You'll have line of sight immediately into what the impact of that relationship is, as opposed to spending tens and tens of thousands of dollars over the next 18 months to try to resolve something through a piece of civil litigation.
Yeah, thank you, Jeff. That's to interject a little bit of levity into the discussion. Hearing a litigator advise us and our clients not to pursue litigation, I guess, is a sobering way to start the day.
It pains me to do so, Erik. It really does.
But joking aside, pragmatism, I think for those of us in West Michigan in particular, we're familiar, and other parts of the country as well. I think people are coming together to be pragmatic about how to deal with these types of situations. But I think that's a real strength of our community that's ingrained in West Michigan to kind of work collaboratively on these things. And we're seeing the best of people both here and elsewhere kind of work together to come through these situations without having to try to litigate it. And maybe it's good that option will be off the table effectively for a while. One other area moving on the agenda that I think is important for companies to continue to keep in mind, even though it's hard when everybody's working remotely or many people are working remotely, is the need to continue to keep board members and officers informed, and to remember that that internal controls still apply to transactions that are undertaken by the business even during extraordinary situations. I think businesses are going to need to be flexible and creative about ensuring that material information is still flowing to the right people within the organization, whether that's in the case of financial information to the Treasury and Finance team and the CFO's office, whether that's in the case of cybersecurity, data breach issues going to Chief Information Officer, whether it's, in the case of fraud that may be identified within the organization. I think as people find new ways to work and start, dusting off resources that they may not have used in the past to work remotely and to achieve other business objectives, we may see that some fraud or fraud-like activities are uncovered. Communicating that to the audit committee and other constituents within the organization is very important. The directors and officers are still obviously subject to fiduciary duties to the company and its shareholders, and they have the duty of care to keep themselves informed. If they're a public company or an exchange-listed company, additional duties that you're subject to in terms of internal controls and disclosure requirements. And we don't have time to get into all of those additional regulations on this call. I'm sure if there are people from public companies on the line, you're dealing with that in your SEC filings and risk factors. But set that aside, just even for privately held companies, it's important to remember that you're still subject to fiduciary duties if you're a director or an officer, and you need to make sure that you're getting access to the material information that you need to run your business day to day. And that includes, new contracts that may be entered into. It may cover things that we've already talked about, like if you are serving a termination notice or on the receiving end of a termination notice, attempting to renegotiate a material contract. Obviously, changes in financial circumstances need to be communicated. So I think it's important for organizations to reinforce to employees and to make sure that employees understand how they should be communicating material new information up the chain to ensure that key decision makers are informed, and that the right internal constituents have the information and day-to-day changes and circumstances that they need in order to manage the company. Okay. That'll bring us close to the end here. We have about 10 minutes left, and so I want to spend a few minutes talking about the overall theme here, which is really choosing among bad options in the environment that we're in right now. I don't think there's any panacea to a lot of the circumstances we're going to be facing when it comes to making decisions about whether to comply with the contract or to breach or to serve notice that you may not be able to perform. I want to just reemphasize that all these decisions are being made against a backdrop that's very different than they normally would be made in the case of just general financial uncertainty, and that is a human backdrop where human health and safety are on the line, and that is another potential risk and something we all care about, obviously, in our organizations. And so when we're thinking about choosing among bad options, I think it's important that somebody be an advocate internally to remind organizations that there may be an option that's not a great one, but that prioritizes employee or other community member health and safety above some immediate commercial concerns. And those are going to be excruciating decisions to have to face, but you don't have to face them alone. You have other professionals and teams in your organizations to help you make those decisions and to evaluate and to see around corners that may not, that you may not have total visibility around right now. And so you should not be shy about taking advantage of those resources. If anybody else on the Miller Johnson team has something they'd like to comment on here as we conclude and before we pivot to any Q&A, I'll pause for a minute to welcome those thoughts and observations.
Yeah, Erik, this is Anne Marie, and I think, thank you everyone for joining us this morning as we launch this webinar effort as an opportunity for a collective meeting of the minds as we work through the mental gymnastics of how do we see around the corners that we don't have visibility to right now. I would really invite folks to extend the invitation to additional context and to register for tomorrow's webinar. And included with that registration, we'll have the opportunity for you to submit questions in advance. One of the topics we would like to cover tomorrow, and we'll have specialists on the phone addressing, will be real property matters, whether it's leases or premises liability, those sorts of issues. So please think through how we can best provide some information or dialogue around the problems you're facing in those areas. Jeff, is there anything you would like to add?
No, thanks, Anne Marie, and thank you everybody for joining this morning. I hope that you found the webinar helpful and informative. And I would just invite those on the call today, if they have any particular or specific questions, to feel free to reach out to any of us directly. We are, kind of living in this space right now, and anything that we can do to help is you try to go through your risk mitigation efforts. We're happy to do so.
Yeah, thank you, Jeff. And this is Erik. I'll wrap up. I don't think we have any. I'm looking at the Q&A, unless Anne Marie or others see questions. Right now, I think we'll wrap up and let people get on to what I'm sure is a very busy day. But to just echo and reemphasize what Anne Marie and Jeff have said, we are partners with our clients in these difficult times. please feel free to reach out to any of us. If there's something we cannot answer immediately, we will bring in other firm resources or other professionals in our networks to help clients and community members work through an extraordinarily challenging time. So with that, thank you again for joining. Please stay safe and healthy today, and we will talk with you again tomorrow morning if you're able to join us, or any other morning this week, 8 a.m. Eastern Time. Thank you.